Listen, if you're a creator or entrepreneur, you cannot afford to sleep on this common IP mistake. Stay with me. Arthur, I said do not sleep.
Yes. Yes, of course. Of course.
I'm Kyle Siegel, business exec, entrepreneur, and award-winning intellectual property lawyer. I created this channel to help creators and entrepreneurs make smarter moves around intellectual property or IP. Whether you're launching a product, building a brand, or growing an audience, IP is one of the most valuable things that you'll ever own, and understanding how it works can give you a serious edge. But let's be real, legal content is usually boring, complicated, and full of insider jargon.
I am the esteemed Arthur P. Willingham.
This channel is different. You'll find plain English, quick-hitting explainers to boost your awareness and up your IP game.
Ah, yes, the noble enterprise of creation and commerce. Pray, mark well this instruction and carry it close as provision for the road ahead.
Enough gobbledygook, Arthur. You know the rules. No stuffy lawyer talk here. Look, this isn't legal advice, and no, I'm not your lawyer, but this is smart, digestible info to help you unlock the full potential of your creativity and innovation. So subscribe, hit the notifications bell, and let's go.
Onward and tally-ho!
I want to tell you a secret I've observed over and over again after 13 years of working in the trenches of the intellectual property world. Can I tell you? Come here. Most creators and entrepreneurs have created way more IP than they even realize, and they're leaving potential value and important tools on the table. Let's fix that. All right, friends, these are the core categories of IP that you need to know as you grow your business or following. First, copyrights. They protect original, creative works. We're talking graphics, videos, scripts, books, music, art, and even software code. Government registration is optional and smart in certain situations, but it's not required. Copyrights spring to life automatically the moment you create a work outside your brain. Idea in your head for a children's book? Nope, no copyrights until you actually make the book. But you outline your latest video script in a notebook? Boom, copyrights. You filmed your latest reel footage on your phone, or you wrote some software code on your laptop? Yep, copyrights. Copyrights let you control copying, digital downloads, distribution, and even a person's ability to make modified versions of your work.
Like in this classic teaching example where Disney enforced its copyrights in Mickey Mouse illustrations to stop a group of underground cartoonists called the Air Pirates from publishing comics that showed Mickey Mouse in sex and drug-fueled situations.
Verily, copyrights help to secure your market share and forfend scoundrels from dragging your artistry through the mud.
Second, trademarks. These are brand elements, names, logos, slogans, and sometimes even unique look and feel of products or packaging. They help your customers and followers know that your product came from you as opposed to someone else. Why is that important? Because if people love what you're offering, like your content or a product, they'll probably want other stuff from you too. And they'll tell their friends and followers to do the same. And that is what we call building a brand. But for people to come back and want more of your stuff in the future, they need to reliably know where to get more of that same good stuff and where to point people. Why do I say reliably know? Because as you deliver offerings people love, they begin to get the warm and fuzzies when they see your name and logo. They associate that name and logo with quality, value, or whatever it is driving their decision to buy or engage. Then, when they're shopping again in the future, those warm and fuzzies, that sense of trust in your company, that automatically steers them back to your company again. But you let some copycat slang low-quality knockoffs with your name or logo on them, and your customers or your followers' hard-earned trust can vanish overnight, leaving people too confused and hesitant to risk their money on your questionable product. And that's why we have trademarks, which, come to think of it, should probably be called trust marks. Here's an example where OpenAI was concerned about this exact issue of losing customer trust due to confusion in the marketplace. It sued Open Artificial Intelligence, a different company that was using the OpenAI trademark. Ultimately, OpenAI got the court to permanently stop this other company from using OpenAI. Government registration is optional and smart in many situations, but it's not required. And trademark rights actually last, generally, as long as you keep using them with the products you're actively selling or marketing.
And in case you need convincing that trademarks are important to customers, just ask Cracker Barrel, which lost $100 million in value recently for changing its logo from this logo to this logo.
If you want a quick-hitting, plain English, real-life dispute involving trademarks and the overall look and feel of products, and even design patents, check out this video. Third, patents.
For the full and proper edification of our esteemed viewers, I will now read from Title 35, Section 271 of the United States Code, and don't you dare interrupt me, you intolerable simpleton! Now, except as otherwise provided in this title, whoever without authority.
Regular patents protect how your product or process works, its functional features, and special ones called design patents protect a product's overall look and feel. Remember the reward-based sharing system we talked about earlier? Here's the deal. You tell us in your patent application how your invention works, and if your invention is truly unique compared to everything that came before it, you'll get your reward, a patent that lets you block others from using it without your permission, even people that didn't mean to copy your product or didn't even know about your patent. The right patent can be an incredibly powerful tool for innovators, entrepreneurs, founders, and creators. But here's the big trade. Patents are public documents, so everyone gets to learn about how your invention works, and they don't last forever. Patents generally last 15 to 20 years, and after all the patents covering your product's functionality have expired, anyone is free to use it. And in the meantime, because patents are public, people can read them, get inspired, and create new innovations based on your original invention. And that's how creativity and innovation compounds over time to give us incredible things, from life-saving medical treatments to the device you're using to watch this video right now.
Here's a simplified example. Imagine your innovation is a high-tech manufacturing process inside this factory. Now, once you filed a patent application for your innovation, your situation actually looks more like this. Why? Because your patent application must explain how to make and use your innovation. And because patent applications and patents are generally public documents, anyone in the public can see into your factory to understand how your innovation works. But if the patent office approves your patent application and grants you an actual patent, then your situation actually looks more like this. You see, in exchange for telling the public how to make and use your innovation, your patent gives you the right to stop anyone else from making, using, selling, offering for sale, or importing your innovation. People can see inside the factory, but the patent is like this wall that prevents them from using what they see. Because your wall generally lasts for 15 to 20 years, the only way they really have a shot at getting to your innovation, even though they could see it, is if you give them permission to walk through the front gate. That permission is often called a license, and because licenses are super customizable, this makes your patent a powerful tool for building collaborations and protecting your business from free riders.
High-quality patents can be expensive, so to avoid wasting money, patents should only be pursued thoughtfully with a focus on protecting the unique features that actually drive value.
Permit me to enlighten you. The word patent comes from the Latin patere, which means to lie open.
Arthur! Okay, that's actually kind of interesting. Anyway, fourth, trade secrets. Trade secrets are valuable information like customer lists, formulas, algorithms, that kind of stuff that you keep secret. Like legit secret. We're talking vaults, splitting recipes across numerous people so nobody knows the full thing, that kind of stuff. Okay, not always that extreme, but you get the point. Some famous trade secrets over the years which you'll recognize as things not so easy to figure out: the Coca-Cola formula and Google's search rank algorithm.
Or my very own mustache cream, Willingham's Whiskers, named after yours truly, of course, and brewed, I confess, in my own bathtub. On sale now at McGillicuddy & Sons Dry Goods and Sundries. Hurry now while supplies last.
Unlike patents, where protection applies even if somebody unintentionally or even unknowingly uses your patented invention without your permission, trade secrets only are protected against theft. Think an employee leaves your company for a competitor, takes your secret algorithm or your pricing list with them, and gives it to their new employer. Or hackers, just hackers.
Here's a recent example where a company called KPM Analytics was able to use its trade secret rights to stop a competitor from using trade secret information it had acquired from former KPM employees. In the court filings, you'll see that the court actually held the individual former KPM employees liable. Ouch!
No government registration and protection lasts for as long as you actually guard it as a secret. But if someone just independently creates the same thing you consider a trade secret, like an algorithm, or they lawfully reverse engineer your product to figure it out, trade secrets won't help you.
Keep your tinkering paws away from my mustache cream.
Finally, publicity rights, sometimes called NIL or name, image, and likeness, especially in the sports context. These protect your name, face, voice, and likeness. Basically, others can't slap you on an ad without your permission.
By my seal, no one shall profit off the good name or the absurdly handsome countenance of Arthur P. Willingham without rendering the piper his proper due.
Here's your takeaway. IP, creations of the mind, are almost everywhere we look in life. And as a creator or entrepreneur, you've probably created way more IP than you even realize. IP is one of the most important assets creators and entrepreneurs will ever own. Don't sleep on it. Recognize the IP you've already created and will create in the future. Understand how to leverage it as a powerful tool for building collaborations and dissuading copycats and bad actors from free riding on your creativity, innovation, and hard work. Comment below. What type of IP have you created during your journey as a creator, innovator, founder, or entrepreneur? Tell us your story. Let's make this a community where we share our journeys and support one another. If you like this type of quick-hitting, plain English breakdown crafted specifically for creators and entrepreneurs, and you want me to make more content like this, let me know and let the algorithm know by liking, subscribing, hitting that notifications bell, and sharing this video with a creator or entrepreneur in your life. If you want a refresher on the fundamental reason IP exists and how to use it, check out this video.
And as for me, I have the honor to remain your most humble and obedient servant, Arthur P. Willingham.
Bye, Arthur!
No.